We're happy to have Professor Jay Thomas from Georgetown Law with us again this year. Professor Thomas, thanks for being with us. This year, the court decided a case concerning the circumstances under which enhanced damages could be awarded in willful infringement cases. So what was the law of willful infringement prior to HALO versus Pulse Electronics?
So the Patent Act just says the damages can be tripled or trebled in cases of patent infringement. It just says may. The case law for a long time has held that an appropriate circumstances for enhancing damages is indeed willful infringement. The big case was a 2007 decision from the Federal Circuit called Seagate, and it set up a two-part standard. There was an objective side and there was a subjective side. The objective test said that objectively the patent infringer should have known that it was engaging in conduct that would infringe a valid patent. And subjectively, itself had to know, that the actual actor itself had to be aware of this possibility. The patent holder had to prove both of those factors by the clear and convincing evidence standard.
So what's the impact of HALO versus Pulse Electronics?
Well, the principal impact is to get rid of the objective side. So effectively, the Supreme Court said having that objective standard was inconsistent with the statute. The term may granted a lot of discretion to the trial courts, the Supreme Court said, and sort of shoehorning into this objective standard was inappropriate. The court was also concerned that this focus should be what the accused infringer did at the time of infringement. It would be too easy later in trial to come up with some excuse that the patent was invalid or not infringed, when that wasn't part of the decision making at the time. Also, the standard of proof was lowered for the new subjective only test.
How did the court lower the standard of proof? What is it now?
It's now just a mere preponderance. It used to be the clear and convincing higher standard.
Okay. And what is the standard for awarding enhanced damages? Is that the clear and convincing, or is it preponderance?
It's just a preponderance at this point, and it's just the subjective test. So the adjudicated infringer had to engage in culpable, egregious behavior. It had to know about a valid patent, it had to believe it was infringing, and it had to continue its actions anyway. The court stresses that these aren't for mine run cases. It's got to be something special.
Were you surprised by this one?
Not at all. There were two 2014 cases from the court, and those decisions dealt with the sister statute with the award of attorney fees. And these are Octane Fitness and Highmark, by the way.
Okay.
And the Federal Circuit had set up a similar kind of standard for the award of attorney fees, and the Supreme Court knocked that back. So this was sort of a pretty easy follow-up. In fact, the Supreme Court seemed a little impatient with the Federal Circuit, quite frankly.
Okay. Do you think that enhanced damages are going to increase as a result of this?
Absolutely, because the substantive standard for awarding them is more lenient, and also the standard review on appeal is now abuse of discretion. So I think it's easier to get an award, and I think that once the award is given out, it'll be sustained on appeal more easily.
Okay. So what do you think? Is this a good development for the patent system?
Well, in a sense, the Supreme Court's been seen as leading a charge to soften the patent system, okay, to pull back the strict proprietary rights that patents have been granting. So this kind of bucks that trend because it makes patents a little more potent. The damages can be higher. On the other hand, this may put more stress on the ability or the willingness of technology companies to have to obtain advice of counsel. Congress recently amended the Patent Act, and cases have been drifting away from this requirement that before you engage in any activity, you do research on a patent and get an opinion of patent counsel about the validity of the patent and whether you infringe it or not. So if there's no objective test anymore and you're just looking at the subjective decision-making process at the time of infringement, I think it puts a little bit more stress on getting these opinion letters again.
Okay. Well, now what about the other patent case that the court took up? That was Cuso Speed versus Lee.
Exactly. So that one has a little bit less to do with the courts. It's more about the patent office. So at the USPTO, there is a new proceeding called Inter Partes Review, and it's an administrative patent revocation proceeding. They've proven fabulously popular, and they've been effective in striking down patents. There was a challenge about what the standard of claim interpretation is. Patents have many claims that those set out the proprietary rights possessed by the patent owner. And the Patent Office has been interpreting them under the broadest reasonable construction standard. That differs what goes on in the court, which is the ordinary meeting standard under the famous Markman case. Mm-hmm. So the Patent Office's claim construction stance was upheld. So it's still broadest reasonable interpretation. And also the Supreme Court held that there was no appeal from the Patent Office's initial decision to grant an inter partes review in keeping with the statute.
So what are the implications of this Cuso decision?
Well, I think inter partes review are going to remain very popular for accused infringers or patent challengers. And I think Congress intended these proceedings to sort of be a substitute for patent litigation. But what we're seeing is they proceed in parallel with patent litigation. So if you're accused of infringement in court, you'll often bring this proceeding at the Patent Office. So courts are still going to have to deal with these parallel proceedings on the same patents going on contemporaneously.
Okay. Well, thanks for being with us again this year, Professor. And now Beth Wiggins with a look at criminal law.
Hello. Before we start about the criminal law cases, I would like to correct a small mistake we made in the first part of the program. We misspoke a case name. It's CRST Van Expedited, not CSRT Van Expedited. Okay, so now to the criminal cases. Canons of statutory construction are intellectual devices for helping judges decipher legal ambiguities, but that doesn't mean the canons themselves are self-evident. In Lockhart versus United States, the majority and the dissenters disagreed about which canon they should use. Avondale Lockhart was convicted of possessing child pornography in violation of 18 U.S.C. section 2252A4. Defendants convicted under that statute are subject to a 10-year mandatory minimum sentence and an increased maximum sentence if they have, quote, a prior conviction under the laws of any state relating to aggravated sexual abuse, or abusive sexual conduct involving a minor or ward. Laurie, what was the argument about how this statute was applied in Lockhart?
Well, Lockhart had a prior New York State conviction for aggravated sexual abuse on his adult girlfriend. He argued that this conviction should not lead to the enhanced sentence because it did not involve a minor or ward. But the court held against Lockhart, and it based its ruling on the rule of the last antecedent, which says that if there's a modifying phrase like involving a minor or ward, it modifies only the noun or phrase that it immediately follows. So in this case, that would have been the abuse of sexual conduct. Lockhart's case was one that involved aggravated sexual abuse. It was the first term in the list of offenses, and the fact that it involved an adult, not a minor or ward, didn't mean that it didn't qualify for the enhancement statute applicable in the pornography case. Justice Sotomayor wrote for the majority, and she said that's what the court typically uses and does in interpreting statutes that include a list of terms followed by a phrase that has a limiting clause.
Yeah, Justice Kagan wrote the dissent, and she was joined by Justice Ginsburg. She agreed with Lockhart that the proper canon to apply was the series qualifier canon. She wrote that it was clear from the language of the statute and from Congress's legislative intent that the lawmakers meant for the qualifying phrase involving a minor or ward to apply to all the terms in the list of offenses. And each of the justices had her own colorful example of why she had applied the correct canon. Justice Sotomayor said that if the general manager of the Yankees had told one of his scouts to find a defensive catcher, a quick-footed shortstop, or a pitcher from the previous year's World Series winners, it would be natural for the scout to look for a pitcher from last year's champions, in this case the Kansas City Royals, but to look more broadly for catchers and shortstops.
Yes, Evan, but Justice Kagan countered that if a friend told you that she hoped to meet an actor, a director, or producer involved with the new Star Wars movies, you would know immediately that she wanted to meet an actor from the Star Wars cast and not from a different movie.
So in a sense, the Yankees prevailed over the Empire.
You got it.
Yeah.
Okay. Our next decision, Mathis versus United States, was also about whether a previous state conviction qualified as a predicate for a harsher federal sentence. The Armed Career Criminal Act, or ACCA, imposes a 15-year mandatory minimum sentence on a defendant convicted of being a felon in possession of a firearm if the defendant also has 3 prior state or federal convictions for a violent felony, including burglary, arson, or extortion. To determine whether a prior conviction is for one of those 3 crimes, courts ask whether the elements of the offense forming the basis for the conviction sufficiently match the elements of the generic version of the crime. This is called the categorical approach. Elements are the parts of the crime's legal definition that must be proved beyond a reasonable doubt to obtain a conviction. Facts, or means, are seen as mere real-world things, the details of specific crimes in extraneous to the crime's legal definition. When a statute defines multiple crimes by listing multiple alternative elements, courts use the so-called modified categorical approach to distinguish between elements and means. The modified categorical approach allows courts to look at a limited class of documents from the record of the prior conviction to determine from the facts what crime with what elements a defendant was convicted of before comparing that crime's elements to the generic offense. So, Evan, how did this distinction play out in Mathis?
When Mathis was convicted as a felon in possession of a firearm, prosecutors sought under the ACCA to impose a 15-year mandatory minimum based on a number of the convictions that he had suffered under the Iowa burglary statute. But the problem here was that the Iowa statute includes land, water, and air vehicles as places that can be burgled, whereas the generic definition of burglary only includes unlawful entry into fixed structures like houses. So the Iowa statute was, quote unquote, overbroad for purposes of the ACCA. The district court in this case had used the modified categorical approach, looked at some documents in the record and determined that Mathis had burgled houses and not cars or boats. The Eighth Circuit affirmed that conviction, saying that the use of the modified categorical approach was proper, whether the overbroad terms in the Iowa statute constituted elements or means.
But Justice Kagan, in writing for the majority, said that that distinction between elements and means makes all the difference, and that the modified categorical approach can only be used if the overbroad terms are elements. Here, the Iowa statute, the terms were just means, so they could not be used, and the court was barred from looking down at the trial record to see if, in fact, these prior convictions qualified as predicate crimes under the ACCA. She said that this is the fairest approach and the one that complies with Apprendi.
Justices Breyer and Ginsburg dissented. They said that the distinction between elements and means or elements and facts shouldn't make a difference in sentencing, and that it would be a difficult distinction for the lower courts to carry out with respect to state burglary statutes like Iowa's. They felt that in this case, the court documents, the record made it clear that Mathis was convicted for unlawfully entering an occupied structure, and that met the generic definition of burglary.
Okay. In Luna Torres versus Lynch, the court had to decide whether it mattered that a state statute that otherwise seemed to meet the definition of an aggravated felony under the Immigration and Nationality Act, or INA, lacked an interstate commerce element. The INA defines aggravated felony by listing various crimes, most of which are identified as offenses described in specific provisions of the Federal Criminal Code. Following that list, the statute provides that the referenced offenses are aggravated felonies, whether they are, and here's the important language, in violation of federal, state, or foreign law. Luna Torres was convicted of arson under a New York state law that was defined in the same way as a federal arson offense, except that it lacked the interstate commerce element. The Supreme Court held that that did not matter. Justice Kagan again wrote for the majority opinion, saying that the INA uses a phrase described in to define which state criminal laws are covered. And the sentence that says the listed offenses are aggravated felonies, whether they are in violation of federal, state, or foreign law, makes it clear that Congress meant both federal and state statutes to constitute aggravated felonies. There were two petitioners in our next case, Stephen Voisin and William Armstrong. Each of them was convicted under Maine state law of physically abusing their girlfriends, and both were banned by federal law from possessing firearms as a result of those convictions. 18 U.S.C. Section 922G9 prohibits any person convicted of a misdemeanor crime of domestic violence from possessing a firearm. That includes any misdemeanor involving the use of physical force. Voisin and Armstrong were convicted of misdemeanors, making it unlawful to inflict not just knowing and intentional bodily injury, but to do so recklessly as well. When they were charged with unrelated federal crimes years later, prosecutors found out about their prior domestic violence convictions and that each owned firearms. That led the prosecutors to add charges under 922G9. So, Laurie, what did the petitioners argue here?
Well, they were arguing that only knowingly and intentionally causing injury qualified under this statute, but the Supreme Court disagreed. They said that when the statute uses the word use in 922G9, it does not exclude an act of force that involves a conscious disregard of a substantial risk of harm, and that assaults that are involving recklessness are categorically different from those that are just mere negligence or an accident. For example, if you have someone who throws a plate against a wall, it's foreseeable that when it shatters, it might injure a spouse. That's different from just dropping a plate by accident.
Yeah, I think it's worth pointing out that this is the latest in a series of decisions broadly construing which domestic violence convictions qualify for federal criminal and immigration consequences in both United States versus Hayes in 2009 and then Castleman versus the United States in 2014. The court seemed to want to be inclusive in finding state convictions to qualify for federal consequences in a way that will protect domestic partners.
Our next three decisions involve different aspects of the Hobbs Act. But in the first, Ocasio versus United States, there was a bit of a twist. Evan, can you tell us about that?
Ocasio was a Baltimore police officer who directed cars that were damaged in traffic accidents to a place called the Majestic Auto Repair Shop in exchange for kickbacks from the owner. Ocasio was convicted of obtaining the money from the shop owner under color of official right in violation of the Hobbs Act. And all the parties agreed that this Hobbs Act extortion was the functional equivalent of taking a bribe. But then he was also convicted, he was charged with and convicted of conspiring to violate the Hobbs Act. Ocasio challenged the conspiracy conviction, arguing that as a matter of law, he couldn't be convicted of conspiring with the shop owners to obtain money from them under color of official right. But the court held against Ocasio. The majority wrote that a defendant could be convicted of conspiring to violate the Hobbs Act, so long as he entered into a conspiracy that has as its objective the obtaining of money from another conspirator with his consent and under color of official right.
And this case is a great primer on conspiracy law, that a defendant can be guilty of conspiracy even if the defendant himself could not commit the substantive crime. It's enough if the conspirators agree that the underlying crime be committed by a member of the conspiracy who is capable of committing it. And they use the analogy to perhaps a prosecution under the Mann Act of a woman, now who she's being transported for immoral purposes, which violates the statute. She can be punished for conspiring to willingly participate in this with others who are crossing the state line with her.
Although the majority cautioned that its decision does not extend to cases where the person paying the bribe is an unwilling participant in the scheme. In a case like that, the official is guilty of simple extortion of the private individual, and there's no conspiracy between the two of them.
Okay. The Hobbs Act punishes anyone who in any way or degree obstructs, delays, or affects commerce or the movement of any article or commodity in commerce by robbery or attempts or conspires to do so. The Act defines commerce broadly as interstate commerce and all other commerce over which the United States has jurisdiction. In Taylor v. United States, the petitioner was originally convicted of violating the Hobbs Act by robbing two marijuana dealers, hoping to obtain large amounts of drugs, cash, and other valuables. What was Taylor's argument in this case, Laurie?
Taylor's argument is that he challenged the Hobbs Act conviction on the grounds that the marijuana he was robbing was just from a local grower and therefore did not affect interstate commerce. Justice Alito had no part of that. He said, writing for the majority, that this really was a straightforward case involving the court's decision in 2005 of Gonzalez versus Raich. There, the court had said that the Commerce Clause gives Congress, in fact, the authority to regulate the national market for marijuana. That might involve just prescribing against purely interstate production. And since the Hobbs Act criminalizes robberies and attempted robberies that affect any commerce over which the U.S. has jurisdiction, this did satisfy the Hobbs Act, and the government would not have to prove in the case that the robbery was affecting interstate commerce. It's enough that it was the local growers.
Right. The court emphasized that this decision applied only to robberies of drug dealers when the robber is targeting drugs or other drug proceeds.
Okay. Well, finally, we have the much anticipated decision in McDonnell versus United States. Virginia Governor Bob McDonnell was convicted of what amounted to bribery under the Federal Honest Services Fraud and Extortion Statutes for arranging calls, meetings, and events for businessman Johnny Williams. Williams was trying to get Virginia's public universities to do research that would have benefited his business. In return for that help, McDonnell and his wife received about $175,000 in loans and luxury goods from Williams. Under the Honest Services Fraud and Extortion Statutes, prosecutors must prove official acts were performed. I think everyone knows that the court overturned Governor McDonnell's conviction. Evan, what was the court's reasoning, though?
Well, the government had argued that almost everything that a public official does constitutes an official act, including things like arranging calls or meetings or events. The court unanimously rejected that line of argument. It held that an official act requires a decision or an action on a question or matter that involves a formal exercise of governmental power, that it has to be something specific and focused, that is pending, or that may be brought before a public official. But it would be sufficient. The court took pains to say that it would be sufficient if an official agreed to take such an action, even if that action was never really taken.
Yeah, you know, McDonnell had asked that the court actually find the Hobbs Act unconstitutionally vague, but given the narrow finding by the court that they didn't have to reach that ruling. However, I think the bottom line here is that prosecutors have become very aggressive in the use of the Hobbs Act. The court sent the message, walk it back. Official acts have to be more than just setting up a meeting or an introduction. They actually must be efforts to influence acts in specific matters pending before an official or an agency.
Thanks, Laurie, and thanks, Evan. I think we have a couple questions.
We do. The first one coming in is, after the Mathis decision, how do we decide what the difference is between element and means?
I think that's a great question. And in fact, some of the members of the court were saying, I'm not sure we can do that. But I think elements are sort of the broader terms of what have to be proved, and means are more descriptive of how you're going to prove that action taking place. We'll have to wait for the lower courts to make some decisions in this area.
Yeah, I would just add that the majority opinion, Justice Kagan did lay out several different methods of telling the difference between elements and means. You certainly look at the text of the statute. That's one criterion. Sometimes the statute is written in such a way that it makes that fairly clear. But in the last resort, she said that there was a peek that is authorized, a peek for the limited purpose, a peek at the record for the limited purpose of figuring out whether it involves elements or means, and that's kind of the last resort.
Okay, now we have one on the McDonnell case. Does McDonnell limiting the definition of official act under 18 U.S.C. Section 201 impact other honest services and bribery statutes like 18 U.S.C. 1346 and 666 that do not explicitly define or require an official act? Any
I
thoughts?
don't know that we know the answer to that. I do know that, in fact, the court has been quite concerned recently with the Hobbs Act. We've seen several decisions in this area, but I would expect lawyers to be raising that question of whether that same language has been used. And a few years ago, we did have some concerns about the honest services statute. That's always been a bit vulnerable to attack. It's going to come down, I think, to how prosecutors bring these cases. If they bring them on sort of simple actions, you might very well see that type of argument made.
All right.
Thank you. Next, we're going to talk about some criminal procedure decisions.
Now from criminal law to criminal procedure. We're going to look at 5 of these, starting with 2 cases where the court made the rare finding of retroactivity. The first was in Montgomery versus Louisiana. In 1963, at age 17, Henry Montgomery killed the deputy sheriff and was given a sentence of life without parole. Now 69 years old, Montgomery asked that the Supreme Court's 2012 decision in Miller versus Alabama be applied retroactively to sentences like his that were final before Miller was decided. In Miller, the court held that sentencing juveniles to life without parole was a violation of the 8th Amendment's ban on cruel and unusual punishment. Erwin, what was the majority's rationale for finding Miller applied retroactively in Montgomery's case?
In Teague versus Lane in 1989, the Supreme Court held that one of its decisions about criminal procedure applies retroactively in 2 circumstances. One is if it's a watershed rule of criminal procedure. Since 1989, nothing has been found to be a watershed rule of criminal procedure. The other, court said, is a situation where a Supreme Court decision puts a matter beyond the constitutional reach of the criminal law. The court said a substantive change in the law will apply retroactively, where a procedural change in the law won't apply retroactively. A substantive change in the law includes if the Supreme Court says that a particular punishment violates the 8th Amendment is applied to a particular class or group or status.
So when a state enforces a penalty that's barred by the Constitution, then that conviction or sentence is, by definition, unlawful.
Exactly.
Okay.
And that's what the Supreme Court held in Montgomery versus Louisiana. Miller versus Alabama held that it's cruel and unusual punishment in violation of the 8th Amendment to have a mandatory sentence of life without parole for a homicide committed by a juvenile. The court in Montgomery says that's a substantive change in the law, therefore it applies retroactively.
Now, Laurie, Justice Scalia wrote a pretty forceful dissent in this case, didn't he?
I believe he did. In this case, he said that the ruling in Teague, frankly, is not constitutionally required. He wrote that the decision in Miller was a procedural change, but it didn't completely ban a life imprisonment sentence for a juvenile. It just mandated a certain process to be followed before you find whether that defendant is incorrigible. Moreover, Justice Scalia said, you know, it's very difficult for judges 50 years later to go back and make that type of assessment of whether Montgomery should have gotten that sentence.
I think this case is important in a couple of ways. Obviously, for anyone who received a mandatory sentence of life without parole for a homicide committed by a juvenile before Miller versus Alabama, they now can get relief. The other is the court clarified that Supreme Court decisions apply retroactively if they're substantive rather than procedural. The problem, though, is that the distinction between substance and procedure is often very elusive.
Laurie, how does our next decision in Welch versus United States, how does that approach the retroactivity question?
Jim, in very much the same way, frankly. Last term, as you'll recall, in Johnson versus United States, the Supreme Court ruled that the residual clause of the Armed Career Criminal Act, or the ACCA, was unconstitutionally vague. The ACCA increases the sentence for a felon in possession of a firearm from 10 years to a mandatory 15 years to life in prison if the offender has 3 prior convictions for a serious drug offense or a violent felony. Now, the definition of a violent felony has this residual clause, and we have it up on the screen, I think, and it says that it is any felony that, quote, otherwise involves conduct that presents a serious potential risk of injury to another. That's the clause that the court found to be unconstitutionally vague in Johnson. The court again applied, as Erwin was talking about, the Teague versus Lane standard here in Welsh, and found that whereas procedural rules are not retroactive, here what we had was another substantive rule change. And it found that Johnson was a new substantive rule because it altered the range of conduct or the class of persons who could be punished under the law. So Johnson had the effect of basically putting out of reach the use of this statute, and it wasn't just judicial procedure, and therefore it would be retroactive.
All right, so what do these two decisions taken together say to you?
I think they actually signal a greater willingness by the Supreme Court to find areas in criminal procedure to be retroactive by saying that they are a substantive change in the law, not just procedural.
I think it's also worth mentioning that the court did not discuss or even allude to how Johnson and Welch might apply to other federal statutes, use some language, or the sentencing guidelines. It was discussed in oral argument, but the court just didn't speak to it.
All right, our third decision deals with what is often the meat and potatoes of criminal procedure, Fourth Amendment search and seizure issues. It is Utah versus Strieff. Salt Lake City narcotics detective Douglas Frackle was surveilling an alleged drug house when he saw Edward Strieff come out and walk to the local convenience store. Frackle stopped Strieff in the store's parking lot, identified himself, and asked Strieff what he was doing in the house. Frackle had no reasonable suspicion on which to stop Strieff at this point. After getting Strieff's name from him, Frackle found out from the dispatcher that Strieff had an outstanding arrest warrant against him for a traffic violation. Frackle testified, he arrested Strieff on that warrant, and incident to the arrest, he searched Strieff and found drugs and drug paraphernalia in Strieff's pocket. At his trial, Strieff asked the court to apply the exclusionary rule and suppress admission of the drugs as evidence because they were the fruits of an unlawful search. So, Erwin, how did that work out for him?
The Utah Supreme Court said that the evidence should have been excluded as the fruit of the poisonous tree, but the United States Supreme Court, in a 5-3 decision, reversed the Utah Supreme Court. The Supreme Court held that the evidence should have been admitted. Justice Thomas wrote the opinion for the court, and he focused on the attenuation exception to the exclusionary rule.
And using that attenuation exception, the court set up a 3-part standard to make the determination of whether the seizure is the result of this illegal stop. It said, look, we've got 3 things. 1, temporal proximity. In other words, how much time has passed since the time of the unconstitutional action and when they obtained the evidence. The second is intervening circumstances. Did something happen between the unconstitutional action and finding that evidence? And the third thing was the purpose and flagrancy of the police misconduct. Did the officers know that they were obviously doing something unconstitutional? Now, the court said here, look, given the temporal proximity, we kind of have to admit that that was very close. They stopped the guy, found the warrant, and they did the search, got the evidence. So that one goes in favor of him. On the other hand, the court found that there were these intervening acts, which was an arrest based upon a lawful warrant, which allows Frackle to do exactly what he did. And then the court basically said that even though the government had conceded this was an unlawful stop, it was only negligent. It wasn't a flagrant violation of Strieff's constitutional rights, and therefore they were going to use the attenuation doctrine, not the exclusionary rule.
And there were a couple of dissents in this case, including a pretty remarkable one from Justice Sotomayor.
Justice Sotomayor wrote a powerful dissent. She talked about how many outstanding arrest warrants exist, including for minor crimes. She talked about how degrading it is to be stopped by a police officer. She talked especially about the effect of this in minority communities. In fact, I think we've put on the screen some of the language from Justice Sotomayor's dissent, where she says, "This case allows the police to stop you on the street, demand your identification, and check it for outstanding warrants, even if you are doing nothing wrong. If the officer discovers a warrant for a fine you forgot to pay, courts will now excuse his illegal stop and will admit into evidence anything he happens to find by searching you after arresting you on the warrant."
Yeah, Justice Kagan also wrote a separate dissent in this case, and she said that even if we use these factors, the majority had misapplied the factors. There are so many warrants out there. There are communities where 70% or more of the people might have some type of outstanding warrant, maybe for a low-level offense, like a traffic offense, and police routinely check for these warrants. So how much of an intervening act can that really be if the police know they're always going to do it and it always is going to happen? She said it was predictable and it was intentional on the officer's part, and therefore they should not be using this attenuation doctrine.
I think the important issue for the lower courts can be, when is police conduct so flagrant that the attenuation exception won't apply and the exclusionary rule will have to be applied?
All right, thank you. The scope of the search incident to arrest exception was also a major focus of our next decision, Birchfield versus North Dakota. Birchfield was actually 3 cases decided together, asking whether warrantless breathalyzer and blood tests that are given to suspected drunk drivers violate their Fourth Amendment rights. In one of the 3 cases, the driver refused to take a blood test. In the second, the driver was arrested and charged with refusing to take a breath test. And in the third case, the driver agreed to have blood drawn, but then subsequently argued that his consent had been coerced. Now, all 50 states have laws requiring drivers, as a condition of operating a motor vehicle within the state, to give implied consent to blood alcohol concentration tests if they're arrested or detained on suspicion of driving under the influence. If they refuse to take the tests, suspending or revoking their license is the standard consequence. But some states have now passed laws making it a crime to refuse the testing. So after this decision, I'm wondering if police need warrants before testing drunk drivers? Laurie?
Sometimes yes, sometimes no. The majority reviewed the search incident to arrest doctrine and was balancing, frankly, the privacy interests of drivers against very strong government's interest in stopping and deterring drunk driving. And they came to the conclusion that, at least with regard to breath tests, it's a negligible intrusion on the driver's privacy right. You blow into a straw, it doesn't really give the police any more information than whether your blood alcohol level is over the amount permitted, but that's about it. That's with regard to breath tests, and therefore those are allowed.
And what about the blood tests?
Justice Alito, writing for the court, said that blood tests are different. He said blood tests involve piercing the skin. He said a great deal more can be learned by analyzing a person's blood than just what we learned from somebody's breath. So when it comes to blood tests, the court has said the police cannot draw blood unless there's either a warrant or exigent circumstances.
What about concurrences, dissents? Were there in this case?
There were a couple of opinions that were both concurrences and dissents. Justice Sotomayor wrote an opinion concurring and dissenting, joined by Justice Ginsburg. Justice Sotomayor said for both breath and blood tests, a warrant should be required absent exigent circumstances. She stressed how easy it is to get a warrant. Justice Thomas wrote an opinion, concurring and dissenting, coming to exactly the opposite conclusion. He said there shouldn't need to be a warrant for either blood tests or breath tests. He said in all driving under the influence cases, there's exigent circumstances that justify allowing the police to go forward.
You know, I think there are 2 big takeaways from this case. The first is absent exigent circumstances. You need to get a warrant for a blood test, not for a breath test. But I think the second is that this decision does not preclude states from having those laws that suspend licenses or impose civil sanctions or administrative sanctions for refusing to take any type of test.
There was strong language in our next decision, Foster versus Chapman, and this time from the Chief Justice. When Timothy Foster, a black man, was tried for capital murder, the prosecutor peremptorily struck all 4 black prospective jurors. Foster objected at trial that those strikes were racially motivated in violation of the court's ruling in Batson versus Kentucky. The trial judge overruled the objections. Foster was convicted and sentenced to death, and while Foster's state habeas petition was pending, he obtained copies through the Georgia Open Records Act of the file used by the prosecution. One of the documents in that file was the jury Venire list, on which the name of every potential black juror was highlighted to denote the race. Another document was a draft affidavit from an investigator comparing prospective black jurors and pointing to one that, quote, might be okay if the prosecutors had to pick one of them. Other notes had the capital letter N, meaning no, next to the name of every black juror. Other findings suggesting racial motivations for the peremptory strikes also existed. So, Laurie, remind us now about Batson versus Kentucky first.
You know, as you said, Batson was the Supreme Court's decision holding that jurors cannot be struck for racial reasons. And since then, that's been applied on the basis of gender as well. And the court set out a 3-step process for determining whether this has happened. The first step will be for a defendant to make a prima facie case that there have been peremptory challenges made on the basis of race. Then second, the prosecution offers a race-neutral reason for exercising their strike. And finally, and importantly, the court must decide whether the defendant has been subject to this purposeful discrimination by the prosecution. And actually, what we're talking about here is the jurors' rights, regardless of the race of the defendant.
Erwin, so did the Supreme Court find that the prosecution had violated Mr. Foster's rights in this case?
Without a doubt. Chief Justice Roberts wrote the opinion for the court. He said it violates the Constitution for even one prospective juror to be excluded on the basis of race. He said the court couldn't turn a blind eye to the evidence in this record. He focused on the 3rd prong of the Batson test that Laurie just described. He looked at 2 particular jurors and said that the evidence was overwhelming that they had been excluded on the basis of race.
You know, Erwin, I think this is a really important case because it reaffirms Batson, and it sends a message to everybody that racial discrimination in jury selection should not be tolerated, frankly, on either side. On the other hand, I don't know if other defendants are going to be so lucky to find the type of record that they found in this case.
Thank you all.
We have a question.
Great.
And that is, does the decision in Foster versus Chapman mean there will be less deference towards state courts on Batson challenges?
I don't think necessarily that's what it means at all. This was a pretty extreme case. I do think that when you have these things in writing, it's really hard. On the other hand, there was a controversy in the court about whether enough deference was given.
I think the court is trying to send a message to state and to federal courts to be more vigilant, making sure that race and sex are not infamously used in excluding prospective jurors. I agree with Laurie that there's extreme facts here. How often will a defendant find documents like this? But I think the court is trying to send a message. It wants them to take Batson more seriously.
Thank you. And now let's take a look at some Sixth Amendment decisions.
The Sixth Amendment to the U.S. Constitution guarantees criminal defendants, among other things, a quick and speedy trial before an impartial jury and the assistance of counsel for their defense. The question of how to interpret and apply those rights in actual criminal cases was before the Supreme Court in our next 4 decisions. In Hearst versus Florida, it was the right to be judged by a jury that occupied the justices. Timothy Lee Hearst was convicted of murdering his co-worker, Cynthia Harrison. A penalty-phase jury recommended 7 to 5 that Hearst be executed. But Florida law required the judge to hold a separate hearing to decide whether there were sufficient aggravated circumstances to justify the death penalty. The judge found that such circumstances existed and then sentenced Hearst to death. Hearst argued that that was a violation of the Sixth Amendment right. What did the court decide, Evan?
The court ruled in favor of Hearst 8-1. the court reiterated the holding of its 2002 decision in Ring versus Arizona, which had been based on Apprendi versus New Jersey, that a capital defendant has the right to have a jury, and not just a judge, find all facts necessary to impose the death penalty. Now, Florida argued that the jury's recommendation of the death penalty included within it an implied finding of aggravated circumstances, but the justices rejected that argument and pointed out that the Florida capital sentencing procedure explicitly requires findings by the judge to impose death.
And Justice Sotomayor noted that just like in Ring, the maximum that sentence Hearst could have received based just on the jury's recommendation was life without the possibility of parole. So that really did require the judge to find those facts that would be necessary to impose death. And as Evan said, that's what violates the Sixth Amendment.
And the court here expressly overruled two of its own pre-Ring versus Arizona decisions that had previously upheld the constitutionality of Florida's capital sentencing scheme. Time and subsequent decisions like Ring had, quote unquote, washed away their logic, said the court.
But there was a dissent by Justice Alito in this case. He argued that the decision did not follow from Ring because there were different roles of the judge and the jury in each case. And he said even if there was a constitutional violation, the harmless error doctrine should apply.
Okay. The right to a speedy trial was the focus of our next decision, Betterman versus Montana. Brandon Betterman was jailed for over 14 months while waiting to be sentenced on a bail jumping conviction. The delay was institutional. The pre-sentence report took nearly 5 months to complete. The trial court took several months to deny 2 pre-sentence motions, and then the court was slow in setting a sentencing hearing. Betterman was eventually sentenced to 7 years imprisonment, with 4 of those suspended. On appeal, Betterman claimed that the 14-month delay between conviction and sentencing violated his Sixth Amendment speedy trial right. Laurie, did the court agree?
No, the court did not. The court basically divided the criminal prosecution of cases into 3 phases. It said that in the first phase, which is the pre-charge phase, a defendant's rights are protected by statute of limitations. The second phase, which is post-charges until the time of trial, that's what's protected by the Speedy Trial Clause. And then finally, that third phase, from the conviction by the jury or guilty plea until sentencing, that's to be protected by the due process rights, not by speedy trial. And the defendant could argue that period of time was constitutionally excessive.
And the court said that in an appropriate case, due process may provide the source of some sort of tailored relief, which presumably is some kind of an order to enter a sentence within a certain period of time. But the problem here was that Betterman didn't preserve that due process argument in front of the Supreme Court. And as the court said, the speedy trial right doesn't apply in the sentencing phase.
Justice Sotomayor wrote a concurring opinion directed to the lower courts. She said if a lower court is hearing a due process challenge to delay, it should apply the test from Barker versus Wingo. And that's a 4-part test. It looks at the length of the delay, the justification of the delay, the defendant's objections, and the degree of prejudice to the defendant. And she said lower courts are already using this under due process.
Okay. Our final 2 decisions deal with the Sixth Amendment's right to counsel. In the first, Luis versus United States, we have a plurality opinion written by Justice Breyer for himself, the Chief Justice, and Justices Ginsburg and Sotomayor. Justice Thomas concurred in the judgment, and Justices Kennedy, Alito, and Kagan all dissented. So, Evan, what were the facts in question before the court?
Luis was charged by a grand jury with healthcare fraud and some related crimes. The government said that she'd made nearly $45 million from her crime and that she'd already spent most of it. The government hoped to preserve the $2 million that Luis still had in order to cover restitution and other criminal penalties in the event that she was convicted. And these kinds of funds are called criminal forfeitures, and they can include assets not related to the crime as well as tainted assets. So in order to preserve the $2 million, the government sought a pretrial order to keep her from, and this is the language of the order, quote, dissipating or otherwise disposing of assets, real or personal, up to the equivalent value of the federal health care fraud. In other words, up to $45 million. Now, both sides agreed that the order would prevent Louise from spending her own funds unrelated to her criminal activity to hire counsel to defend her. So the question before the court was whether the pretrial restraint of a criminal defendant's legitimate, untainted assets that were needed to retain counsel of choice violated the Fifth and Sixth Amendments.
So what did the plurality say?
It ruled in favor of Louise on two different grounds. First of all, it distinguished this case from a couple of previous decisions, Kaplan and Drysdale versus the United States, and then Monsanto versus the United States. The court said that Louise's case was different because the assets that were frozen in those two previous cases were traceable to the alleged crimes.
What was the second reason?
The second reason, we're basically looking at the competing interests in the case. On one hand, you have Louise's Sixth Amendment right to counsel. It's against the second, which is the government's interest in obtaining restitution for the victims. But the first one, that right to counsel, is constitutionally protected. And the court also looked back at common law, legal tradition, and found that basically the right to the forfeited goods was trumped by the constitutional right to counsel. The plurality noted that there had already been too much erosion of the right to counsel, that this would add a burden to federal public defenders who are already overworked and underpaid, and that frankly it felt confident that the prosecutors and the courts, if you follow that clear line of allowing the seizure of tainted assets but not untainted assets, would be a workable standard.
And what about the concurrence, Evan?
Justice Thomas concurred in the judgment, but he rejected the plurality's balancing test. He relied instead on the lack of a common law history of the government seizing untainted assets before trial.
And the dissent, Erwin?
There were two dissenting opinions. Justice Kennedy read a dissent joined by Justice Alito. He said that he believed that the Kaplan and Drysdale and Monsanto cases resolved this issue. He expressed great concern that this would give defendants an incentive to dissipate their assets so they wouldn't be available for restitution. Justice Kagan wrote a separate dissenting opinion, making basically the same points.
Okay. Well, finally, we want to tell you about the decision in United States versus Bryant. Responding to the high incidence of domestic violence against Native American women, Congress passed a law in 2005 aimed at serial offenders. The law made it a federal crime for any person to commit a domestic assault within Indian country if that person has at least 2 prior final convictions for domestic violence rendered by federal, state, or Indian tribal court proceedings. Michael Bryant had multiple tribal court convictions for domestic violence for which he was imprisoned, but never for more than a year. Bryant maintained that his tribal court convictions did not count under federal law because he was not represented by counsel in those proceedings. While the Sixth Amendment guarantees appointed counsel to indigent offenders in federal and state court, tribal courts under a separate sovereign only require appointment of counsel if a sentence of more than 1 year is to be imposed. So Bryant's uncounseled convictions in tribal court for terms of less than 1 year were valid when entered and could be used as predicate offenses under Congress's 2005 anti-domestic violence law, according to the Supreme Court in this decision. Now here's John Cooke with some final words.
That's our program for this year. We hope you found it useful and interesting. Please take the time to fill out the online evaluation form that you'll find on the same page as the written materials at our website. It's the only way for us to know how we can improve this program and make it even more useful for you in your work for the courts. I thank our faculty for again helping us examine these decisions and everyone here at the Federal Judicial Center responsible for producing this program. I'm John Cooke. Thank you for watching.